Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 36. The case I'll discuss today is about whether a public school employee's statement about his colleagues' paperwork skills was considered defamatory. Let's first look at the case. Jeffrey Cruce had been the head football coach and athletic director at Berkeley High School in South Carolina since 2011. For the 2015 season, he adopted a controversial no-punt offensive strategy for the 2015 football season. This approach sparked intense debate among the followers of the team and attracted attention from both football and national media. The controversy intensified after the football team suffered lopsided defeat. In December 2015, the school district deputy superintendent notified Cruce that he would be reassigned to a middle school guidance counselor position because he had failed to meet performance goals. The reason for his reassignment was not disclosed publicly. In January 2016, Chris Stevens, the athletic trainer at Berkeley High School, sent an email to 45 people, including administrators, athletic department employees, and volunteer coaches. In the email, Stevens questioned the integrity and the completeness of student-athlete files Cruce had managed. Stevens stated in the email that essential information from the student-athlete files could be missing, and the filing issue were a potential liability to the school district. The next day, the superintendent affirmed Cruce's reassignment. Cruce finished the school year in his new position, but resigned at the end of the school year. In his resignation letter, Cruce expressed that the school district had humiliated him and destroyed his career by removing him from his coaching and athletic director positions without any public explanation. Following his resignation, Cruce moved out of state, struggling to find any coaching jobs or even a position as a volunteer coach, which he attributed to the school district's action. Cruce filed a lawsuit against the school district, alleging wrongful termination and defamation, particularly focused on Stevens' emails. The jury awarded Cruce $200,000 in actual damages for defamation. However, this decision was overturned on appeal because Cruce was considered a public official. This legal battle reached the appellate level, questioning whether Cruce, a football coach, was a public official or public figure. Why does the characterization of a public official or public figure matter in defamation cases? This is because the distinction between public officials, public figures, and private individuals significantly influence the burden of proof in a defamation lawsuit. What is a defamation? It refers to a statement that tends to attack the honesty, integrity, virtue, or reputation of a person and exposes the person to disgrace, public hatred, avoidance, contempt, or ridicule. There are two types of defamation: libel and slander. Libel refers to defamatory statements that are made in writing or published. It can cause long-term damage to a person's reputation because it has a potentially wider spread and can exist in the long term. Slander refers to defamatory statements that are spoken. To prove defamation, a plaintiff generally must show four things. First, a false statement purporting to be fact. Second, publication or communication of that statement to a third person. Third, fault amounting to at least negligence. And fourth, damages or some harm caused to the reputation of the person or entity who is the subject of the statement. First, the statement made must be demonstrably untrue, and it should be presented as a fact rather than an opinion. For example, if someone falsely claims that a restaurant owner has been reusing ingredients from the customer's plates, this is a factual statement that it can't be proven false. If your supervisor wrongly accuses you of embezzlement in a staff meeting, this statement is factual and can be proven false. But if your supervisor states in the meeting that she feels an employee may not be trustworthy, this is an expression of opinion rather than a factual assertion. It's less likely to be considered defamatory. Second, the defamatory statement must have been communicated to at least one person other than the plaintiff. This doesn't necessarily mean publication in a newspaper or online. It could be as simple as verbally spreading statement in a meeting or in an email circulated among colleagues. For example, a supervisor discusses an employee's alleged misconduct during a departmental conference call, spreading the false information to multiple colleagues. But if a supervisor writes a private note to himself about suspicion of an employee's behavior, but never shares it with anyone, there has been no publication. In the case I discussed today, Stephen's email was sent to 45 people in the school district. Third, the person who made the statement must have shown a lack of care regarding the truth of the statement. Negligence is sufficient to meet this criteria in many cases, especially if the defamed person is a private individual. This means the speaker failed to do something a reasonable person would have done to verify the information before sharing it, such as check the accuracy of the accusation before discussing it publicly. For example, a human resources director fails to verify a negative report about an employee's work history from an anonymous source before discussing it during a performance review. If a manager repeats information that was believed to be accurate and had been verified through reliable sources at the time, it may not constitute negligence, even if the information later turns out to be inaccurate. In this case, the court noted that Stevens could have been reckless. Stevens was not authorized to review student athletes' files, nor was he trained to know the applicable requirements. Still, he rummaged through the files and broadcast his belief about Cruce's integrity to 45 of Cruce's peers. After declaring the files were incomplete or out of order, Stevens reported he could continue reviewing them over the next few days to make sure the correct files are in place. This remark shows Stevens' review of the files before sending the email was cursory and incomplete. Fourth, the plaintiff must show that the false statement caused harm to his reputation. This could include losing business, being shunned by peers, or suffering mental anguish directly related to the defamation. For example, an employee is demoted or loses professional opportunities because colleagues or administrators believe the false statements about their conduct. In this case, Cruce testified to his humiliation, how his reputation was ruined due to the school district conduct towards him, how he could not find another job in coaching, that he was shunned, and that there was a black mark on his name. After understanding what defamation is, the next question is, why does the characterization of a public official or public figure matter in defamation cases? If Cruce is a private individual, he only needs to meet the 4 criteria I just mentioned. But if Cruce is a public official or public figure, in addition to the criteria above, he must face a higher burden of proof. It means Cruce must prove actual malice, which means that Stevens knowingly made a false statement or recklessly failed to check the accuracy of the statement. Cruce was employed by a public school district and a high school football coach and athletic director. Was he a public official? The South Carolina Supreme Court's answer was no. To qualify as a public official, the plaintiff must occupy a position that would invite public scrutiny and discussion of the person holding it entirely apart from the scrutiny and discussion occasioned by the particular charges in the controversy. School board members are elected or appointed to oversee the management of school districts, set policies, and make decisions. They are public officials. Superintendents are senior administrators responsible for managing the public school districts, implementing school board policies, and overseeing daily operations of schools. They are public officials. Principals are administrators who manage individual schools, are responsible for enforcing school district policies at the school level and overseeing both academic and administrative functions. They are public officials. Although Cruce enjoyed media attention as a football coach, it did not transform him into a public official, a classification that would strip him of his right to protect his name from being defamed to the same extent as a private citizen. No matter how intense the public gaze may be upon sports figures, they do not have any official influence or decision-making authority about serious issues of public policy or core government functions, such as defense, public health and safety, budgeting, infrastructure, taxation, or law and order. It is these public issues and functions that the First Amendment recognizes as so essential to democracy that public debate about them and their policymakers should be unchecked, except where the speech is knowingly false or uttered with reckless regard of its truth or falsity. That is, the actual malice standard of New York Times v. Solomon. A high school football coach is not a public official because his coaching duties are ancillary to core functions of government. Put simply, football is not fundamental to democracy. The school district also argues that if Cruce was not a public official, then he was a public figure, at least a limited public figure. What's key? What does a limited public figure mean? They are those who voluntarily inject themselves or are drawn into a particular controversy and thereby becomes a public figure for a limited range of issues. The requirement for limited public figures to prove actual malice in defamation cases comes from their voluntary decision to engage in public controversies. By stepping into the bully pulpit of public debate, one must expect to endure the slants and arrows of outrageous, but not knowingly or recklessly false statements hurled in the hurly-burly civic discourse. Here, a bully pulpit is a prominent public position that provides an individual with the opportunity to speak out and be listened to on any issue. It was a term coined by U.S. President Theodore Roosevelt, referring to his office as a bully pulpit, meaning a superb platform from which to advocate an agenda. Roosevelt used the word bully as an adjective, meaning superb or wonderful, which was a more common usage at the time. The patriots who fought to found our country were not cowards. They did not fear political battle and knew that freedom to speak out against the government was the oxygen of democracy. They were aware through bitter experience that the stifling of speech was a preferred weapon of tyranny because it replaces tolerance with repression, producing a climate of fear, anger, and apathy that can topple republics. Here, the court used a three-part test to decide whether Cruce was a limited public figure. First, whether the plaintiff voluntarily injected himself into and played a prominent role in a public controversy, defined as a controversy whose reputation affects a substantial segment of the public. Second, whether the defamation occurred after the plaintiff voluntarily entered the controversy, but while still embroiled in it. And third, whether the defamation was related to the controversy. The court reasoned that there was no public controversy because the merit of Cruce's coaching strategy was not a controversy that affected large segments of society. Even if a public controversy existed over Cruce's coaching strategy, Stevens' defamatory comments related to Cruce's paperwork skills, not his gridiron acumen. As a result, the court ruled that Cruce was not a public official or a public figure, and that his defamation claim was supported by evidence, reversing the decision of the Court of Appeals and reinstating the jury's damages award. What can educational administrators learn from this case? First, administrators need to be clear about what defamation is, particularly distinguishing between statements of fact and opinion. This case highlights the importance of understanding that public officials and public figures have different standards of proof for defamation claims, specifically the requirement for public officials or figures to demonstrate actual malice, which means knowingly make a false statement or recklessly failing to check accuracy. Second, when sending emails that could potentially contain sensitive information, it's important to be cautious, particularly with a statement that could be interpreted as defamatory. Before making any accusations or statements about someone's conduct or character, ensure that you have verified the truthfulness of those statements beyond doubt. This requires a rigorous fact-checking process where gather solid evidence before making any assertions. Focus primarily on factual information in your communication. It not only helps in maintaining professionalism, but also shields you and your organization from potential legal repercussions. When describing events or behaviors, avoid adjective language that could be misinterpreted or seen as accusatory without evidence. Instead, describe events or behaviors with clarity and precision. Stick strictly to verifiable facts. Moreover, consider the potential impact of your words on the recipient and other readers. Words have a power and can affect reputations and careers significantly. Therefore, thoughtful and responsible communication is essential, especially in professional settings where the stakes are high. A cautious approach not only prevents misunderstandings and disputes, but also creates a more respectful and constructive workplace environment. Third, Cruce's case highlights the need for transparency and fairness in administrative decisions, especially those involving reassignment or dismissal. When you need to make those important decisions, it is imperative to communicate the reasons behind the decisions clearly and factually to all involved parties. This communication should not only outline the specific reasons for the decision, but also be backed by concrete evidence and established criteria used to reach the decision. The decision-making process should be transparent and fair.